Live stream servisi de aktiftir. Dilerseniz başlayabiliriz Aliye Hanım.
Başlayabiliriz.
Distinguished participants, ladies and gentlemen, good morning, good afternoon, and good evening, depending on your location of origins. My name is Murat Sevgi. On behalf of SESREC, we would like to welcome you for today's training courses on personal protective equipment and market surveillance and inspection of personal protective equipment. We will begin right now with opening remarks. Then we will take a couple of minutes to execute the group photo. Then we will continue our training sessions. First of all, we would all like to welcome you on behalf of SESREC. And now we are going to open our training session with welcoming remarks. Ms. Aliye Sharife Ortak will deliver her opening remark on behalf of SESREC. So the floor is yours, Aliye Hanım. Welcome once again. Good morning.
Thank you, Mr. Murat. Bismillahirrahmanirrahim. Distinguished participants, ladies and gentlemen, Assalamu alaikum wa rahmatullahi wa barakatuh. A very good day to all of you. We are delighted to welcome you all to the training course on personal protective equipment and market surveillance and inspection of personal protective equipment, which we are jointly organizing with the Directorate General of Occupational Safety and Health under the Ministry of Labor and Social Security of Republic of Turkey, within the framework of the OIC Occupational Safety and Health Network, OIC OSHNET, and Occupational Safety and Health Capacity Building Program, OSHCAP. At the outset, I would like to convey the heartfelt greetings of Her Excellency Mrs. Zahra Zumrut Salchuk, Director General of SESREC, to all participants and speakers attending these training courses. We would also like to express our sincere thanks and appreciation to Ms. Nasib Gul Archuban, OSH expert and market surveillance inspector at the Directorate General of Occupational Safety and Health of Turkey. Its short name is DEGOSH, for her collaboration and contribution to the training courses by delivering and opening remarks onto this important subject. Our heartfelt thanks and appreciation goes to distinguished speakers from the DEGOSH of Turkey who have dedicated their valuable time to be with us today to share their country experiences. Dear participants, occupational safety and health is paramount importance as it directly influences the well-being of workers, enhances productivity, and fosters a culture of safety in the workplaces. For the OIC, integrating OSH into its agenda is essential not only to comply with the international labor standards, but also to promote economic growth and social equity among its member countries. By prioritizing OSH, OIC member states can significantly reduce workplace accidents and illness, which in turn leads to healthier workforces and increased efficiency. In this regard, SESREC initiated the Occupational Health and Safety Capacity Building Program in 2010 to support efforts of the OIC member countries in improving workplace safety and health. Furthermore, OIC Occupational Safety and Health Network, its short name is OIC OSHNET, is an OIC platform established in 2011 to create closer cooperation among the National Occupational Safety and Health OSH institution of OIC member states through sharing knowledge, experience, and best practices. Since initiation of these two programs, OSHCAP and OIC OSHNET, we have conducted more than 50 various capacity building activities for the benefit of our member countries. Distinguished participants, the training courses on personal protective equipment and market surveillance and inspection of personal protective equipment aim to enhance the knowledge and technical capacity of occupational safety and health professionals from OIC member countries in the categorization and usage of personal protective equipment. It will provide participants with the insights into related regulation and safety standards, promoting effective implementation about the safety practices while raising awareness of innovation and emerging trends in PPE. We are confident that these online activities will contribute to our efforts towards transferring knowledge and expertise among our member countries in this important domain, and add value to the participants' knowledge and experience, as well as promoting their continuous learning in this domain. Before concluding, we wish you to repeat our profound thanks to every one of you for your active participation in these training courses. I believe this will make a positive impact and add value to the work experience of all participants. We wish you all a successful training courses. Assalamu alaikum wa rahmatullahi wa barakatuh. Thank you for your kind attention.
Thank you, Ms. Alyanum, for your sincere welcoming remarks. Ladies and gentlemen, we would like to invite Ms. Nasip Güler Çoban, Occupational Safe and Health Expert and Market Surveillance Inspector under Ministry of Labor and Social Security of the Republic of Turkey. Ms. Nasip Hanım, if you are ready, the floor is yours. Thank you once again for your contributions.
Thank you, Mr. Murat and Mrs. Alia. Ladies and gentlemen and all participants, I send my regards to all of you from Turkey. Welcome to the training on personal protective equipment and market surveillance. This training is organized by Market Surveillance Department. Our department is located under the Directorate General of Occupational Health and Safety and Ministry of Labor and Social Security. First, I want to introduce myself. My name is Gül Erçoban. I am Occupational Health and Safety Expert and Market Surveillance Inspector. I have been working at the department for 19 years. Market Surveillance Department has been carrying out inspections activities of personal protective equipments since 2006. Purpose of the inspections is to ensure the protection of health and safety of PPE users and protect economic operators from unfair competition. Inspections are carried out at sales points, distributors, and production sites to determine the unsafe or non-complying PPEs. Communicating with the economic operators is one of the other duties of us. Also, we investigate the technical files, test the products, take precautions for unsafe products. For non-compliant product, if possible, we take corrective actions to reach the compliant products. If it is not possible to correct the product, we provide destruction of the products. We carry out these duties with 27 personnel. Our head of department is Mr. Abdülhakim Korkutata, and he is sending his regards to all of you. Today, we will be pleased to share our experience with this training. I hope useful information will be provided by this training. I welcome you all again on behalf of my colleagues. Thank you.
Thank you, Nasip Hanım, for your sincere welcoming remarks. Dear distinguished participants, ladies and gentlemen, before we move on to today's session, we would like to kindly ask you to open your cameras for a couple of minutes so that we can take our group photos. If you could collaborate us for a couple of minutes, that would be wonderful. Thank you. Let's wait a couple of minutes, ladies and gentlemen. For those who are able to open their cameras, we would like to kindly ask you to open your cameras. Just a couple of minutes more. Okay. Dear participants, thank you for your collaborations. Thank you so much. Now, our today's training session will start on the topic of law number 72/2023 on product safety and technical regulations. This session will will be brought to you by Mr. Aykut Karakavak, occupational safe and health expert and market surveillance inspector under the Ministry of Labor and Social Security of the Republic of Turkey. Then we will move on to Q&A sessions. Dear Mr. Aykut Karakavak, if you could hear us, the floor is yours. Thank you, sir.
Yes, I can hear you all. Good morning, dear participants. I'm Aykut Karakavak, working for the Ministry for the Occupational Safety and Health, Director General of Occupational Health, Safety and Health for 15 years as a labor expert and market surveillance inspector. Today we will be talking about the law on product safety and technical regulations. This is the outline of the presentation. First of all, we will talk about customs union, then product safety and inspection system, that what it serves, and we will be introduced to law, implementing regulations of the law, purpose, scope, crucial definitions to understand the product safety system in Turkey that is laid down in the law, and product liability, obligations of economic operators, conformity assessment bodies and notified bodies, and then we will talk about market surveillance and administrative fines. We all know Turkey is a member of customs union with European Union. Decision number 195 of the European Community and Turkey Association Council, this is the agreement of customs union, came into effect on 31st December 1995. With the completion of this decision, excuse me, custom duties, quantity restrictions, and measures having equivalent effect have been eliminated in trade of industrial goods between the two parties to ensure free movement of goods, while the common commercial policy, including the common custom tariffs, have been implemented towards third countries. As a result of the customs union, Turkey has opened its internal market to the competition of European Union, while guaranteeing free access of its exporters to the European Union market. Obligations stemming from the customs union can be summarized as alignment to trade policy and preferential trade agreements with third countries, abolition of technical barriers to trade in industrial products, alignment to competition policy and intellectual property law, alignment to customs legislation. Turkey made tremendous efforts in the past 3 decades to become aligned with the European Union's trade and product safety system. As you see, there are 3 crucial parts of this European Union technical legislation. First of all, infrastructure, the notified bodies, conformity assessment bodies, accreditation and standardization. And then we have legislation, we have harmonized and non-harmonized area. If there is an European Union legislation exists, Turkey accepted to adopt it, harmonize it into its legal system. And the last part of the system is controls, import controls, and market surveillance. Product safety and inspection system serves to removal of technical barriers to trade. Technical barriers to trade, as we call, Non-tariff barriers. The different legislations of the countries made that technical barriers. Protection of the reputation of Turkish goods and product safety to protect the users from the non-compliant or unsafe products. The Law on Product Safety and Technical Regulation was published in 12 March 2020, and it entered into force 1 year after its publication. The law aims to set up a general framework to define the main characteristics of the product safety system, such as technical regulations, conformity assessment, conformity marking, CE marking, market surveillance, responsibilities of economic operators, duties of the competent authorities, measures and administrative fines for non-compliances. Due to Turkey's rights and responsibilities stemming from the customs union established within the EU in 1995, the law has been prepared in line with the related European Union legislation. Thus, the law also adopts the main rules brought by the new legislative framework and the goods package of the European Union. Additionally, the main principle of general product safety and product liability was laid down in the law. Main highlights on the framework law are online trade has been included within the scope of the law so that products sold online should be safe and in compliance with the related technical regulations. Thus, competent authorities will be able to carry out market surveillance activities for products sold online. Fines have also been made applicable for internet, radio, or television companies who mediate the sale of non-compliant, unsafe products by including the electronic commerce within the scope of the law. Traceability principle has been introduced to maintain the responsible economic operator for the unsafety or non-compliance. The roles and the responsibilities of economic operators, manufacturer, importer, authorized representative, distributor has been separately defined and maintained. The recall of the unsafe products from the end user has been obligated. Product liability principle has been covered. Effective notification of the public regarding unsafe products have been maintained as one of the key principles of the product safety system. The implementing regulations fall under the law are these regulations prepared by the Ministry of Trade. The regulation on general product safety, that if a product does not have a technical regulation, that falls under this regulation, General Product Safety Regulation. The regulation on market surveillance and inspection of products offered through remote communication tools. The regulation on mutual recognition in the non-harmonized area, CE marking regulation, conformity assessment bodies and notified bodies regulation, conformity assessment methods regulation, the framework regulation on market surveillance and inspection of products, and the last one, regulation on the notification of technical regulations and standards between Turkey and European Union. The purpose of the law is to ensure the products are safe and comply with the relevant technical regulations, to determine the principles of market surveillance and control, the duties of authorized competent authorities and the obligations of economic operators and conformity assessment bodies as stated in the first article of the law. The law covers all products intended to be placed on the market. Placed on the market made available on the market or available in service. Products which exported or intended to be exported to European Union member countries are considered to be placed on the market under this law. If there is a special law regarding a product, the provisions of the law will only be applied in case where there is no special regulation in the special law. Second-hand products are also covered. Products which exported or intended to be exported to countries other than European Union member countries are excluded from the scope of the law. However, it has been stated these products are required to be safe and not subject to adulteration. Also, marking, labeling, and certification of the products should be done in a way that does not mislead the buyer. Product has been defined in the law in a way that can be interpreted quite broadly as all kinds of substances, preparations, or objects. According to the law, the products must be compliant with technical regulations and the products must be safe. We have some crucial definitions laid down in the law. Economic operators means literally a manufacturer, authorized representative, importer, and distributor. Manufacturer means any natural or legal person who manufactures product or has it designed or manufactured and markets it under his name or trademark. This is crucial. We have in the trade system own brand labeling or original manufacturing. You do not have to specifically produce a product. If you market the product in your own trademark, in your name, you would be recognized as manufacturer under this law. Importer means any natural or legal person established within Turkey who imports products and places it on the market. Distributor, any natural or legal person in the supply chain other than the manufacturer or the importer who makes product available on the market. We have two distinct definitions: placing on the market and making available on the market. Making available on the market means any supply of product for distribution or use on the market in course of a commercial activity, whether in return for payment or free of charge. Placing on the market, on the other hand, the first making available of the product on the market. Manufacturer and importer are places products on the market. Only distributor makes product available on the market. We have recall and withdrawal measures that is introduced with this law and mandatory. Recall means any measure aimed at achieving the return of product that has already been made available to the end user. Withdrawal means any measure aimed at preventing a product in the supply chain from being made available on the market. Continued, we have some more definitions: competent authority, non-compliance, risk-bearing or risky product, product presenting a serious risk. Competent authority means the public institution that prepares and implements technical regulation regarding the products and inspects, carries out the market surveillance activities of the product. Non-compliance means a failure to comply with any requirement under the technical regulation. One of the basic concepts that we see in the law is risky or risk-bearing product. It has been defined as the product that is likely to negatively affect human health and safety, workplace health and safety, or other public benefits beyond the reasonable and acceptable extent under the relevant technical regulation or general product safety regulation, including the intended use of the product and duration of use and when it is possible. installation maintenance requirements within the normal and predictable conditions of use of the product. If there is a non-compliant or risky product, the economic operators shall take the appropriate and necessary measures in the law in a timely and effective manner to make the product compliant and to stop the product's placing on the market. When necessary, we have measures. The economic operator has to withdraw or recall the product by respecting the principle of proportionality. Otherwise, the competent authority, the market surveillance authority, may require the economic operator to take necessary measures by setting a time limit when necessary. In case where the product is risky, the economic operators informs the competent authority in detail and promptly about the issues that pose a risk, especially in terms of health and safety, and the corrective measures taken. Also announce information about these measures and the risks of the product in an effective way to protect the end user. In case the other measures taken are insufficient to eliminate the risk, the economic operator recalls the product spontaneously or upon the request of the competent authority. The economic operator shall offer at least one of the options I will tell. First of all, eliminating the problem that causes the product to recall. Payment of the retail value of the product at the time of delivery, or the third one, replacing the product with a safe and equivalent product in accordance with its technical regulation. Product presenting a serious risk means a product presenting a risk for which, based on risk assessment carried out by a competent authority or the economic operator itself, and taking into account the normal and foreseeable use of the product, the combination of the probability of occurrence of a hazard causing harm and the degree of severity of the harm considered to require rapid intervention by the market surveillance authorities, including cases where the effects of the risk are not immediate. Product liability and product liability compensation. The manufacturer or importer has been made obliged to pay compensation for damage caused by an unsafe product. In case of the damage to product or a person as a result of the non-compliance of the product, the manufacturer and the importer of the product shall be responsible for damages. It should be noted that in order for the manufacturer or importer to be held liable, the injured party must prove the damage suffered and the causal link between the damage and the non-conformity of the product. In this respect, the burden of proof is on the party that damaged. In case there is more than one manufacturer or importer, they shall be jointly and severally held responsible. The relevant clauses of contracts relieving the manufacturer or importer from the product liability compensation or limiting such liability shall be null and void. In the event that the manufacturer, authorized representative, or importer of a product cannot be identified, the distributor, which does not provide the name and the contact information of these economic operators or of the previous economic operator of the product in the supply chain within 10 business days as of the notification date of such request by the party who suffers the damage, shall be deemed a manufacturer and shall be liable for the product liability compensation. This is the same as the administrative fines. If a competent authority cannot identify the manufacturer, authorized representative, or importer of a product, the distributor, which does not provide the name and the contact information of these economic operators, or previous economic operator of the product in the supply chain within the 10 business days as a notification of the competent authority, recognized as manufacturer and treated accordingly. The manufacturer or importer can be relieved of liability if they prove that it did not supply the product to the market itself. The non-compliance is caused by the intervention of a third party, for instance, distributor or the user. The non-compliance of the product is caused by its production in accordance with technical regulation or other mandatory technical rules. Now we have obligations of economic operators, first of all, producers. Producers places product on the market that comply with the technical regulation or the general product safety regulation. In cases where the legislation requires, in our case, the personal protective equipment regulation requires for the producer to draw up the technical file, performing the conformity assessment procedures, or have them performed, drawing up the declaration of conformity and affixing conformity mark on the product, in our case, the CE mark. Producer keeps the technical file and documents related to conformity assessment that are issued by a conformity assessment body or notified body for the period specified in technical regulation. Personal protective equipment regulation says this period is 10 years after the last batch placed on the product, placed on the market. Takes the necessary measures to ensure that the product's compliance with the relevant rules continues through serial production, ensures that product carries the model, batch, serial number, or information required by the legislation. In cases where the legislation requires, indicate its name, registered trademark, postal address on the product. If this is not possible, on the product's packaging or in a document accompanying the product. Provides necessary information to end user so that they can avoid the risk that the product may carry. Ensures that the instructions provided to users are in Turkish. In case of non-compliance, fulfills the instructions of the competent authority in the activities carried out to eliminate the risk posed by the products. Importers' obligations. Importer places products on the market that comply with the technical regulation or the general product safety legislation. Before placing the product on the market, confirms that the product bears the conformity mark, CE marking, that the product is accompanied by necessary documents, user's instructions, so on, and that the manufacturer fulfills its obligations. In case where the legislation requires, as I mentioned before, personal protective equipment regulation requires that the economic operators, importers, and manufacturers must indicate their name, registered trademark, and postal address on the product. If this is not possible, on the product's packaging or in a document accompanying the product. Keeps the technical file and documents related to conformity assessment for 10 years. Provides the necessary information to end user so that they can avoid the risk. Ensures that the instructions provided to users are in Turkish. And the distributors, when making product available on the market, distributors shall act with due care. What does that mean? I will explain briefly soon. Before making product available on the market, distributors shall verify that it bears the conformity marking, is accompanied by the required documents and by instructions. Distributors shall ensure that while the product is under their responsibility, its storage or transport conditions do not jeopardize its conformity. Along with the manufacturers and importers, distributors are the third economic operator that subjected specific obligations laid on under the law. The distributor, as I mentioned before, is a natural or legal person in the supply chain other than the manufacturer or importer who makes product available on the market. Retailers, wholesalers, and other distributors in the supply chain are not required to have a preferential relationship with the manufacturer like authorized representative. A distributor acquires product for further distribution either from a manufacturer, from an importer, or from another distributor. Distributors must act with due care in relation to applicable requirements of the technical regulation. Due care refers to the effort made by an ordinarily prudent or reasonable party to avoid harm to another, taking the circumstances into account. It refers to the level of judgment, precaution, prudence, determination, and activity that a person would reasonably be expected to do under particular circumstances. Distributors have to know, for instance, which products must bear the CE marking, what information has to be provided with the product, what are the language requirements for labeling, or user instructions or other accompanying documents, and what is a clear indication of the product being non-compliant. They have an obligation to demonstrate to the national market surveillance authorities or competent authorities that they have acted with due care and make sure that the manufacturer or his authorized representative or the person who provided him with the product has taken the measures required by the technical regulation as far as can be reasonably expected. Another crucial element of the system is conformity assessment. Conformity assessment is the activity of verifying that a standard of or a technical specification was applied in design and manufacturing of a product, device, or system. This activity must be carried out according to a set of well-defined rules, in our case, the standards, to ensure consistent replicable results. Conformity assessment provides the necessary proof based on standards. A product undergoes a conformity assessment before it is placed on the market. To carry out the conformity assessment procedures or have them carried out are the responsible of the manufacturer. Conformity assessment demonstrates that the product meets all legislative requirements. Conformity assessment includes testing, inspection, and certification. The applicable product legislation, or we call technical regulation, specifies the procedures for each product. For instance, personal protective equipment regulation sets out conformity assessment procedures on its annexes. The same as the toys regulation or medical device regulation. It is prohibited to falsely issue, use, falsify, or imitate any conformity markings and certificates, test reports, and other documents related to products required by a technical regulation. In every country, forgery of documents is a criminal offense. Conformity assessment bodies and notified bodies. A conformity assessment body is a body that performs one or several elements of conformity assessment, which are calibration, testing, certification, and inspection. And notified bodies are a specialized kind of conformity assessment body, because notified bodies are designated and notified by the national authority to carry out the procedures for conformity assessment within the meaning of applicable technical regulation when a third party is required. In personal protective equipment regulation, a third party conformity assessment is required for the products fall under category 2 and category 3 risks. My colleagues will briefly explain these issues. Notified bodies and conformity assessment bodies take responsibilities in areas of public interest and therefore they remain accountable to the competent authority. Conformity assessment bodies complies with the procedures and principles laid down in the implementing regulation. We have a regulation on conformity assessment bodies and notified bodies, as I mentioned before, and technical regulations. It provides services in an independent and impartial and transparent manner. It keeps all kinds of documents and records related to its activities for the period specified in technical regulation. This period is 10 years after the issuance of the documents, and submits the documents upon the request of the competent authorities. The competent authority monitors and inspects whether the conformity assessment bodies and notified bodies within its jurisdiction, if they continue to meet the qualifications specified in the implementing and technical regulation. The National Accreditation Body, Turkish Accreditation Agency, TÜRKAK, carries out the accreditation of conformity assessment bodies established in Turkey. Accreditation is a quality infrastructure established to support the reliability and validity of the studies carried out by conformity assessment bodies, and therefore the conformity confirmation documents. The accreditation of conformity assessment bodies is based on the international standards that determine the qualification criteria for relevant conformity assessment bodies. For instance, ISO IEC 17,025 for competence of laboratories, or 17,065 for product certification. Market surveillance is the last part of the system, the control and inspection part of the system. Market surveillance activities carried out means activities carried out and measures taken by competent authorities in order to ensure that the products comply with the requirements specified in the relevant technical regulation or general product safety legislation, and to protect the public interest. The competent authority carries out its inspections within its jurisdiction. For instance, our ministry, the Ministry of Labor and Social Security, is responsible for the personal protective equipment, or Ministry of Health is responsible for the medical devices. Competent authorities carry out their activities by complying with the principles of proportionality and impartiality. Competent authority can inspect the product intended to be placed on the market, made available on the market, or put into service in places deemed necessary, including the warehouse of the economic operator, transportation vehicles, workplace, and production facilities. Competent authority inspects the products within a certain program at a sufficient scale and frequency by checking markings or documents, or by sensory evaluation of the inspectors using their 5 senses to feel the fabric of the product, for instance, when necessary, by taking samples or by on-site inspection or testing. With regard to risk presented by the product, competent authorities shall protect the health and safety of consumers and other end users, takes all necessary measures, including withdrawal and recall of the product. And last part of the presentation is the administrative fines. The law envisaged administrative fines in case of breach of the obligations stipulated thereunder. The administrative fines vary between 3,300 Turkish liras and approximately 2.5 million Turkish liras. Thank you for your attention.
Mr. Aykut Karakolak, thank you for your comprehensive and informative presentation. Before we move on to the next session, we may receive a couple of questions, if you like. Dear participants, for those who have questions regarding the related session, you may write your questions in the chat box or you may speak freely. We could wait for a couple of minutes so that our participants can write their questions, should there any. And in the meantime, I can address a few remarks. The presentations for today's and tomorrow's sessions will be shared with you all participants very soon. Once again, you may write your questions in the chat box or you may speak freely, dear participants. There does not seem to be.
Mr. Murat, may I ask a question?
Nasip Hanım, please.
Some participants asked for the legislation, to share the legislation of Turkey.
Mhm.
Is there any problem to share it in Turkish?
Well, I don't think there would be a problem.
Presentation will be in English, but all of the legislation, maybe
Well,
we
yes.
cannot provide all legislation in English. Is it problem or not?
Understood. I don't think there will be any problem regarding sharing those documents in the original language. So, as indicated, since the presentations cover the main topics in English, in the common language, I don't think there would be any problem regarding sharing those documents in Turkish.
Okay, thank you.
If there are no questions, dear participants, we can move on to the next session. So, Mr. Aykut Bey, on behalf of SESREC, we would like to thank you for your kind collaborations for this comprehensive session. Thank you once again, sir.
Thank you too.
Dear participants, we now move on to the next session called Personal Protective Equipment Directive. And this session will be brought to you by Miss Merve Kuyucu. Miss Merve Hanım, thank you and welcome once again. You are unmuted at the moment.
Okay, thank you, Mr. Murat. Now it's okay. Can you hear me?
We can hear you loud and clear.
Okay.
And we can see your presentation. The floor is
Okay,
yours.
I will
Whenever you
start.
want to, you may go ahead.
Okay. Hello, dear participants. My name is Merve Kuyucu. I have been working as an expert for 12 years. Also, I have been working as a market surveillance inspector for 3 years. Today, I would like to inform you about regulation on personal protective equipment. Here is my outline. First of all, I would like to inform you about new approach. Then I will talk about the parts of regulation on personal protective equipment. They are respectively purpose, scope and exclusions, definitions, obligations of economic operators, other provisions, PPE categorization, and finally, I will finish my presentation with conformity assessment procedures. new approach, the PPE regulation is total harmonization, and a new approach, legislation, aligned to the new legislative framework. It lays down essential health and safety requirements and leaves it to standards, primarily European harmonized standards, to give technical expression of the relevant requirements contained in the regulation. And here are the principles. So, new approach established the following principles. Legislative harmonization is limited to essential requirements that products placed on the community market must meet if they are to benefit from free movement within the community. The technical specifications of products meeting the essential requirements set out in the directives are laid down in harmonized standards. Application of harmonized or other standards remains voluntary, and the manufacturer may always apply other technical specifications to meet the requirements. Products manufactured in compliance with harmonized standards benefit from a presumption of conformity with the corresponding essential requirements. And there are two main regulations on personal protective equipment. One of them is the usage of personal protective equipment at the workplaces. It covers that which personal protective equipment should be chosen in different situations, and how to choose the appropriate PPE according to the different risks. And other regulation which I will inform you is the personal protective equipment regulation. In this regulation, the product is considered commercially. Regulation includes issues such as the features that a PPE must have, its introduction to the market, and the obligations of economic operators. In this context, the two regulations are different. PPE regulation also covers consumer products. These are the main differences. What is personal protective equipment? Equipment designed and manufactured to be worn or held by a person for protection against one or more risks to that person's health or safety. The important point in the definition of PPE is, firstly, whether the product is designed to be suitable for use against a health and safety hazard, and secondly, whether it is personal. For example, while safety helmets protect the head against an impact that may cause injury, are personal protective equipments. However, for example, insulating carpets used in electrical works are used to protect against a health and safety hazard, but they are not considered personal protective equipments because they are not designed to be worn or held by people. In addition to products such as safety helmets, safety gloves, and dust masks used by employees in workplaces, also the protective products used in daily life, such as sunglasses, sports equipments, cyclist helmets, knee pads, arm pads used by children, life jackets, and swimming aids are also personal protective equipments. And these are the equipments: respiratory protection, eye protectors, head protectors, hearing protectors, and goes on. And personal protective equipment regulation covers principles of placing on the market, obligations of economic operators, responsibilities of notified bodies, terms of market surveillance. The regulation clearly defines the obligations and responsibilities of the various economic operators. In general, anyone involved in the supply and distribution chain should take appropriate action to ensure that their PP is in conformity with the regulation. And purpose, this regulation lays down requirements for the design and manufacture of PPE, which is to be made available on the market in order to ensure protection of the health and safety of users and establish rules on the free movement of PPE. And scope and exclusions. This regulation applies to all personal protective equipments, but except these exclusions. Specially designed for use by the armed forces or in the maintenance of public order. For example, the helmets and steel vests used by the police are exceptions of this regulation and designed to be used for self-defense with the exception of PPE intended for sporting activities are exclusions. And also in this private usages are exceptions. Atmospheric conditions that are not of an extreme nature. Important point is extreme nature. And against water and moisture in dishwashing. Used exclusively in maritime and air transport, to which relevant international agreements apply, are exclusions. And for head, face, or eye protection of users that is covered by regulation concerning the approval of protective helmets and their visors for drivers and passengers of motorcycles and mopeds are exceptions. For example, gloves, dishwashing gloves, protective helmets for motorcycle users are exceptions. The basis of the regulation is the product safety and technical regulation law, which Mr. Aykut have just talked about. And again, Mr. Aykut talked about definitions. I will repeat because these are very important. In regulation, there are more definitions. I will only talk about this one. Economic operator covers manufacturers, authorized representatives, importers, and distributors. And manufacturer means any natural or legal person who manufactures PPE or has it designed or manufactured and markets it under his name or trademark. And importer means any natural or legal person established within Turkey who imports personal protective equipment and places it on the market. Distributor means any natural or legal person in the supply chain other than the manufacturer or the importer who makes PPE available on the market. Authorized representative means any natural or legal person established within Turkey who has received a written mandate from a manufacturer to act on his behalf in relation to specified tasks under this regulation. And placing on the market means it is the first making available of PPE on the market. And making available on the market means any supply of PPE for distribution or use on the market in the course of a commercial activity, whether in return for payments or it can be free of charge. And these definitions are important to recall Recall means any measure aimed at achieving the return of the personal protective equipment in the possession of the end user to the economic operator. The important point is from the end user. Withdrawal means any measure aimed at preventing PPE in the supply chain from being made available on the market. After administrative sanctions, according to the situations, after market surveillance, we can apply this, recall or withdraw the PPEs. And the law and regulation covers same topics. So I will again underline the obligations of economic operators. First one is obligations of manufacturers. In regulation, essential health and safety requirements are in Annex 2. The manufacturer shall ensure that the PPE to be placed on the market is designed and manufactured in accordance with these requirements. I will talk about conformity assessment procedures in next slides. Manufacturers shall carry out appropriate conformity assessment procedures or have it carried out. This is an important point. And manufacturer shall draw up the EU Declaration of Conformity. With this declaration, manufacturer acknowledges that the PPE meets essential health and safety requirements. Also, there is a form in the regulation for EU Declaration of Conformity in the part of Annex. After we share the regulation, you can search what is inside in EU Declaration of Conformity. And the manufacturer affixes the CE marking to the PPE. And the manufacturer shall keep the technical documentation and EU Declaration of Conformity for 10 years after the PPE has been placed on the market. Also, the manufacturer shall ensure compliance with the provisions of this regulation in serial production and shall sufficiently take into account if there is change in the design of the PPE and a change in the harmonized standards or any other technical specifications by reference to which the conformity of the PPE is declared. In Regulation Annex 3, there is a technical documentation. Manufacturer shall draw up this documentation according to these requirements. And manufacturer shall ensure that PPE bears a type, batch, or serial number or other elements allowing its identification. And sometimes where the size or the nature of the PPE doesn't allow it, the required information can be provided on the packing or in a document accompanying the PPE. For example, earplugs, they are too small. And this is an important obligation also for manufacturers. For example, if we carried out a market surveillance and find a non-compliance with the PPE, we look its batch and serial number, and we require the economic operator to put an end to the non-compliance concerned. We want them to take all appropriate measures to restrict or prohibit the PPE being made available on the markets, or ensure that it is recalled or withdrawn from the market. If he didn't wear a type, batch, or serial number, he will have to apply these processes for all PPEs. He will recall or withdraw all PPEs from the market. And another obligation. This obligation is very important for us. Manufacturer shall indicate on the PPE his name, his registered trade name or registered trademark, and the address at which he can be contacted. If it is not possible, on his packing or in a document accompanying the PPE, it can be. And another obligation, the manufacturer shall ensure that the EU Declaration of Conformity is provided with the PPE or in the internet address at which the EU Declaration of Conformity can be accessed is included in the instructions manual. Another obligation, the manufacturer shall cooperate with the ministry on any measures to be taken in order to eliminate the risks posed by the PPE. Manufacturer who considers or has reason to believe that PPE is not in conformity with this regulation shall immediately take the corrective measures necessary to bring that PPE into conformity, to withdraw it or to recall it as appropriate. And where the PPE presents a risk, manufacturer shall immediately inform the ministry to that effect. And here are the informations that technical documentation should include. Complete description of PPE and its intended use. Risk assessment of PPE in accordance with the protection purpose. Essential health and safety requires list applicable for PPE. Design and manufacturing drawings of PPE. Definitions and explanations for understanding the drawings. List of applied standards, design calculations and examination results, test reports, protection class, an example of the instruction manual. The manufacturer shall draw up the instruction manual in Turkish, and the information that instruction manual should include is in Annex 2. As you can see, the regulation covers all the information that a manufacturer should implement. And here is the instruction manual. The instruction manual is like a passport and must be in Turkish. The instruction manual must be included in the user manual. The name and address of the manufacturer or authorized representatives, information regarding storage, use, cleaning, maintenance, repair, and disinfection, performance results, the class or level of protection, the service life or expiration date of the PPE or its specific components, the meaning of the markings, the risks against which the PPE is designed to provide protection, a reference to the applicable regulation, the name, address, and identification number of the notified body responsible for the PPE design approval, the reference numbers and dates of the relevant harmonized standards, the website address where the EU Declaration of Conformity can be accessed. I have talked a lot about essential health and safety requirements. Here are the general characteristics required in all PPEs. It should be ergonomic, The levels and classes of protection should be identified. It should provide comfort and effectivity. It should be light and durable, and should contain information to be supplied by the manufacturer. And the PPE itself shouldn't cause hazards. Manufacturer is responsible for placing the safe and compatible product with the technical regulations on the market. In case the manufacturer isn't established in the country, authorized representative or importer is responsible. Now, I will talk about the obligations of importer. The importer shall only place the PPE on the market which is in accordance with the provisions of this regulation. The importer shall ensure that the manufacturer has drawn up the technical documentation, the PPE bears the CE marking, and it is accompanied by the required documents. Where an importer considers or has reason to believe that PPE is not in conformity with the applicable essential health and safety requirements, he shall not place it on the market until it has been brought into conformity. And the importers shall indicate on the PPE their name, registered trade name or registered trademark, and the address at which they can be contacted, or if it is not possible, he can put these informations on its packing or in a document accompanying the PPE. And as I said, the importer shall provide the instruction manual in Turkish with PPE. Another obligation, the importer shall ensure that while the PPE is under their responsibility, storage or transport conditions do not jeopardize its conformity with the applicable essential health and safety requirements. The importer shall keep the technical documentation and EU Declaration of Conformity for 10 years after the PP has been placed on the market. And again, the importer shall provide all information and documentation demonstrating the conformity of the PPE on a recent request from the ministry. The importer shall cooperate with the ministry on any measures to be taken in order to eliminate the risks posed by the PPE. Now, I will continue with the obligations of distributor. The distributor ensures that the PPE it keeps on the market complies with the provisions of regulation. And he or she shall verify that it bears the CE marking and PP has instruction manual in Turkish. Also, distributor shall confirm that PP has type, batch, or serial number or other elements allowing its identification on it, and especially PP has name, registered trade name or registered trademark and address which the manufacturer can be contacted. If the size or the nature of the PP doesn't allow, these informations can be on its packing or in a document accompanying the PPE. And distributors shall ensure that while PP is under their responsibility, its storage or transport conditions do not jeopardize its conformity with the applicable essential health and safety requirements. And again, cooperate with the ministry. The distributor shall provide all information and documentation demonstrating the conformity of the PPE on a reason request from the ministry. Here are the other provisions. An importer or distributor shall be considered as a manufacturer and he shall be subject to the obligations of the manufacturer where he places PPE on the market under his name or trademark or modifies PPE already placed on the market in such a way that compliance with this regulation may be affected. This is important. And economic operators shall be able to present this information for 10 years if requested by the ministry. Any economic operator who has supplied them with PPE and any economic operator to whom they have supplied PPE. Now I will talk about the categories of PPE. Categorization is important for conformity assessment procedures. As the PPE regulation covers such a broad range of products, it divides them into 3 categories based on the associated hazards. It indicates the categories of risks that PPE is intended to protect users from. Category 1, it is PPE of simple design such as gardening gloves. And category 3 is PPE of complex design. For example, respiratory equipments, harnesses. And category 2 is PPE not falling into category 1 or 3. This point is important. If the PPE are intended to provide protection against more than one risk, they shall be placed in the category corresponding to the risks of highest category. And there is communique on the categorization guides of personal protective equipment. The purpose of this guide is to determine which category a personal protective equipment belongs to in order to perform certification procedures. And category 1, personal protective equipment of a simple structure that provides protection against risks that arise gradually and they are at a level that is detectable by the user, his or herself, are classified as category 1. The important point is gradually and detectable risks. It is intended to protect against minimal risks. Category 1 includes exclusively the following minimal risks. Superficial mechanical injuries are, for example, bruises, pricks from plants, and scratches that don't need medical attention. Contact with cleaning materials of weak action or prolonged contact with water. Contact with hot surfaces. Damage to the eyes due to the exposure to sunlight, for example, sunglasses. And atmospheric conditions that are not of an extreme nature can be classified as category 1. And category 2, all personal protective equipments other than category 1 and 3 are classified as category 2. For example, welding masks, gloves that protect against mechanical risks can be classified as category 2. And category 3, it includes exclusively the risks that may cause very serious consequences such as death or irreversible damage to health relating to the followings. For example, substances and mixtures which are hazardous to health, atmospheres with oxygen deficiency, harmful biological agents, high temperature environments, the effects of which are comparable to those of an air temperature of at least 100 centigrade degrees, falling from a height, electric shock and live working, and other things. For category 3, we can give examples such as harnesses, respiratory masks, and all ear protectors are category 3. And now I will explain conformity assessment procedures. In this slide, you can see the conformity assessment procedures. In the chart, technical file and EU declaration on conformity is necessary for all categories 1, 2, 3. And category 1 doesn't require certification by notified body, but category 2 and category 3 must be independently tested by a notified body, and EU type examination is required. For category 2, in addition to the procedures in category 1, the EU declaration of conformity is prepared and the product is CE certified. EU type examination by a notified body before affixing the conformity marking is carried out. And let's look detail. You can see the modules required in this slide. For example, for category 1 PPE, module A is required. It is in only manufacturer's responsibility. And module A involves that the manufacturer implements steps such as preparing technical documentation and CE marking, and he ensures that the PPE complies with this regulation. The manufacturer ensures and declares compliance with the relevant rules within the framework of its own responsibility. For category 2 PPE, module B and module C is required. Both manufacturer and notified bodies responsible. Module B means it involves that where a notified body examines the technical design of PPE and determines whether this design is a conformity assessment in which it verifies and certifies that it complies with the relevant rules of the regulation. Module C is under the responsibility of manufacturer, and it means involves that the manufacturer implements certain steps specified in the regulation, and he ensures that PPE complies with the type described in the EU type examination certificate and the relevant rules of this regulation. For category 3, module B required, and he will choose module C2 or module D, one of them he will apply. Module C2 involves the notified body selecting and removing a random sample of a manufactured items of PPE, which are then tested to ensure continuing compliance. The test program typically involves procedures used in the original EU type examination, but may include other forms of testing to assess homogeneity. And module D involves visiting the production site and checking that factory production control systems used by the manufacturer are capable of enabling consistent production of the certified product. Both module C2 and D assessments are carried out on a regular basis while the item of PPE remains in production. And this is an example for EU type examination certificate. The product is safety glove against mechanical risks, and it is category 2. This certificate is provided by a notified body. For category 1 products, we don't need this EU type examination certificate, as I talked about. And it is important, it is valid for 5 years. Also, I want to show you an example of EU Declaration of Conformity. The product is Safety Vest and it is category 2. This certificate is provided by the manufacturer. In this certificate, the notified body who provided the EU type examination certificate is also indicated in the conformity. For category 3 products, notified body who carries out the module C2 and D controls are indicated also in this documentation. This certificate is also necessary for category 1 products. Manufacturers test their products and prepares EU Declaration of Conformity for category 1. And there are much more information and it's a detailed regulation, but I try to give you the basic and important things. Thank you for all listening me.
Ms. Merve Kuyucu, thank you for your collaborations for this
Thank you.
valuable presentation. Dear participants, before we move on to the break session, we may receive a couple of questions. For those who want to ask questions, you may write your questions in the chat box or you may speak freely. We could wait for a couple of minutes. For those who have questions, you may speak freely or you may write your questions in the chat box. I will help you raise your questions. Ms. Merve Hanım, can you see the questions in the chat box?
How is non-compliance of PPEs identified? Bu uygunsuzluk nasıl şey yapıyoruz? Aftermarket surveillance, we take samples from PPEs, and if we see that is not unsafe, it looks unsafe, we can take samples and we test them. And after the test results, it shows that performance levels and what? If the PPE doesn't pass the test, that is non-compliance PPE.
And also Hamad Bey asked another question. And what happens if non-compliance is detected?
Administrative sanctions we apply. We take corrective measurements for them. If that is unsafe, we want them to recall or withdraw the PPE from the market, and we apply sanctions.
Okay. Thank you, Merve Hanım, for your sincere answers. Dear participants, are there any more questions? And another question by Santongo Ambrose. If I understood right, this product safety law is only for PPEs. Do you collaborate with the national standards body for anything?
What? Mr. Aykut, can you answer the question?
Can I take the question again, please?
Please, Aykut Bey, go ahead. I can speak the question once again. If I understood right, this product safety law is only for PPEs. Do you collaborate with the national standards body for anything?
Okay, first of all, the law on product safety and technical regulations apply to all products, not for PP specifically, but all products must be safe and compliant with its technical regulation. But the technical regulations are product-specific regulations that sets out a group of products specifications. So, in general, this law applies to all products, whether they have a technical regulation or not. Second of all, yes, we have collaboration with the Standards Institution, Turkish Standards Institution. Turkish Standards Institution is a member of Sensenelec, European Standardization Organizations. Thank you.
Thank you, Aykut Bey, for your sincere answer. Arshad Mahmud Bey from Pakistan made a comment. I mentioned earlier in my chat, can you please provide mechanical or technical support for establishing PPE lab in Pakistan? Construction of lab is underway, which will be complete in next year till June. Another question is asked by Soha Ali Yusuf Bey from Sudan. What is the main challenges to implement these regulations and testings? Merve Hanım, would you like to answer that? You're unmuted.
Main challenge and implement these regulations and testing. It is a hard decision because the distributors, we want fatura ne demek? We want bills from the distributors. We try to reach the manufacturers. It is very hard to reach the manufacturers. We cannot find the manufacturer of the PPE because, as I said, they don't put address, marking, any other thing. Sometimes we look and there is no information on PPE. It is very hard to reach the manufacturers. And also during the Mr. Sardar will talk about it in detail how to market surveillance and what we encounters and testing is easy because we look performance levels and a notified body or uygunluk değerlendirme kurulu conformity assessment body product tests, and after these results we understand if the PP is unsafe or not safe. But the hardest point is we cannot reach the manufacturer. Thank you. And
Thank you, Merve Hanım. The last question is asked.
Who are authorized to conduct the PP inspection? We conduct the PP inspection. As I said, my colleague Sardar will talk about how we conduct market surveillance.
One more question is also asked by Santong Ambrose. Is it possible to give us the structure of the Department of Occupational Safety within the Ministry of Labor? I would like to see more details on other staffing. For example, is there a different expert who undertakes the prosecution when there is non-compliance identified with a manufacturer with respect to PPE?
And again, as I know, Mr. Sardar will show you our structure. Maybe it is enough for you, or if it is not enough, you can ask again the structure. For example, is there a different expert who? No, we are the only persons. We are 22 or 25 persons we conduct, and after we apply administrative sanctions.
Okay.
Thank
Thank you,
you.
Merve Hanım. Dear participants, if there are no further questions, we may take a 15-minute break. Our
Mr.
time
Murat,
is Gül Hanım.
there is
Yes.
also one question from Arshad Mahmut.
Gül Hanım,
He is
sorry, we
asking-
could not hear you. Can you repeat it?
Sorry. There is one more question from Arshad Mahmut.
Sorry. Can you see it?
Yes, he is asking, can you please provide mechanical or technical support for establishing PPA lab in Pakistan? Construction of lab is underway,
Yes.
which will be completed in next year till June. I want to answer this question.
Please, Nasip Hanım.
Of course, we can give support in basic level, but our managers will decide this. And maybe if there is a collaboration between two countries and something like a project, we can give support in basic level. Thank you.
Thank you, Nasip Hanım. Dear participants, it is 11:36 in Turkey time. Before we move on to next session, we will have a 15-minute break. We will come back and start at 11:45 in Turkey time. Thank you for your kind understanding and patience. Dear participants, welcome once again. We can start where we left off. Today's last session will be about market surveillance of PPE, and this session will be brought to you by Mr. Sardar Ertuş, Occupational Safe Health Expert and Market Surveillance Inspector at Under Minister of Labor and Social Security of the Republic of Turkey. Mr. Sardar Bey, can you hear us, sir?
Yes, I am hearing you, and I am opening to my presentation.
Hello, sir.
Is it okay?
We can see your presentation. All is set, and the floor is yours. Thank you for your collaborations for today's session. On behalf of SESTRIC, we would like to express our sincere gratitude for your collaborations. Thank you.
Okay, hello everyone. First of all, I would like to thank Mr. Aykut Karakavak and Mrs. Merve for their informative presentations. My name is Serdar Ertuş. I am mining engineer and expert of labor. I have been working as a market surveillance inspector since 2012. Today, I would like to inform you about market surveillance of personal protective equipment in Turkey. Here is my outline. I divided my presentation into four main parts. First of all, I would like to inform you about market surveillance activities. Then I will give you brief information about what is personal protective equipment. After that, I will talk about audit structure of us, and finally, I will conclude my presentation with the information of activities and the meetings. The general objective of market surveillance activities in Turkey are to protect the health and safety of humans, animals, plants, and the environment to ensure that economic operators fulfill their legal obligations for placing safe and compliant products on the market, and also to raise the product safety awareness level of commercial enterprises and regulating these enterprises. Although Turkey is not a member of the European Union, the Custom Union Agreement between Turkey and the European Union was signed in 1995. After that, Turkey became a participant of the free movement of goods, which is one of the four freedoms that form the European single market. According to the agreement, customs legislation of Turkey shall be treated in the accordance with the applicable law of the EU member countries. Market surveillance is the activities carried out by public authorities to ensure that products comply with the requirements set out in the relevant legislation. These actions strengthen health, safety, and other aspects of the public interest, like consumer protection and a level playing field for business. In practice, market surveillance includes any necessary actions stop the circulation of products that do not comply with all requirements set out in the relevant EU harmonization legislation, to bring the products into compliance and to apply sanctions. As a conclusion, main aim of market surveillance is that it is to ensure the supply of compliant and safe products to the market according to the technical regulations. Market surveillance is vital to the smooth functioning of the single market. It is essential in protecting consumers and workers against risk presented by non-compliant products. In addition, market surveillance helps to protect responsible business from unfair competition by economic operators who ignore the rules or cut corners. Standardization and conformity assessment are important elements of the market surveillance of technical products. In brief, the aims of the market surveillance are to ensure placing safe products on the market, protection of consumers' health, and finally, prevention of unfair competition. Market surveillance authorities must have legal power, resources, knowledge to properly perform their functions. As the Ministry of Labor and Social Security, we have been inspecting personal protective equipment in the market with our well-equipped staff since 2007. Market surveillance measures to be taken by the surveillance authorities, such as organizing random and spot checks, obtaining all necessary documentation from manufacturer to evaluate product conformity, when justified, entering manufacturer's premises and taking samples for testing, if authorities find products presenting a risk, they must alert other potential users to those products to reduce the risk of further injury or harm. Products which present a serious risk requiring rapid reaction must be recalled from the market, or measures must be taken in order to ensure that they do not reach the market. Information exchange and effective cross-border cooperation between market surveillance authorities in different member countries is essential to ensure efficient, comprehensive, and consistent market surveillance in the single market. If a surveillance authority spots a product which presents a risk and could have an effect outside the territory of its member state, the information is transmitted to all EU member states using the Rapid Information System, which is simply called RIPEX, that means Rapid Exchange. For example, if one personal protective equipment was produced in Turkey and sent directly to Spain or any European country without being put on Turkish market, is found unsafe by the Spanish or any other countries authorities, market surveillance authorities, Turkey is informed through the rapid exchange system, and we impose the necessary administrative sanctions on the manufacturer company regarding this unsafe product. 9 different public institutions are responsible for performing market surveillance for different product groups in Turkey. Ministry of Industry and Technology is responsible for such as ATX products or lifts. Ministry of Trade is responsible for such as toys, chemical products, children's equipments. Ministry of Health is responsible for cosmetics and medical device. Ministry of Agriculture and Forestry is responsible for such as foodstuff, food contact materials. Ministry of Environment is responsible for construction products and solid fuels. Information and Communication Technologies Authority is responsible for radio and telecommunication terminal equipment. Ministry of Labor and Social Security is responsible for only personal protective equipment. Ministry of Transport is responsible for recreational crafts and marine equipment. Energy Market Regulator Authority is responsible for only fuels. As I said before, our Ministry of Labor and Social Security is responsible for the market surveillance of personal protective equipment. Ministry of Trade is the coordinated organization on the market surveillance activities. Import controls of PPE are carried out again by the Ministry of Trade. The coordination between market surveillance authorities is handled by the again Ministry of Trade throughout the Market Surveillance Coordination Board and the Market Surveillance Product Safety Assessment Board. Now, second part of my presentation is personal protective equipment. What is personal protective equipment. As my colleague Mrs. Merve Kuyucu said in previous presentation, PPE shall mean any device or appliance designed to be worn or held by an individual for protection against one or more health and safety hazards. There are seven main types of personal protective equipment, which namely head protection equipment such as helmet, hearing protection equipment such as earplugs, foot protection equipment such as safety shoes, eye protection equipment such as safety glasses, hand protection equipment such as gloves, protection equipment against fall from height such as full body harness, protective clothing such as high visibility vest. There are three main categories of personal protective equipment. Category 1 is PP of simple design equipment. Category 3 is PP of complex design equipment. Category 2 is PP not falling into category 1 or 3. Gardening gloves or sunglasses are examples of category 1. Protective glove against mechanical risk is example of category 2. Respiratory protection equipment and harnesses are example of category 3. Category 1 is required of internal protection control, which is named as Module A. Category 2 is required of EU type examination, which is named as Module B and followed by conformity to type based on internal protection control, which is named as Module C. Category 3 is also required like Category 2 EU type examination, which is named Module B and followed by conformity to type based on internal protection control plus supervised product checks at random intervals, which is namely Module C, or conformity to type based on quality assurance of production process, which is namely Module D. The root of conformity of PP is determined by the category it falls into which it falls. PP is split into three categories, as I mentioned before. The regulations does not officially define three categories, but it is common practice to refer them as a three. My colleague Mrs. Merve Kuyucu told previous presentation, but because of its importance, I also want to emphasize the root of the conformity for each category. For all categories of products, firstly, a technical documentation must be prepared by manufacturer. After this stage, only for category 1 products, EU conformity declaration is prepared directly and the CE mark is added to the product. Different from category 1, for category 2 and category 3 products, a notified body must be involved in second stage. For products in these categories, an EU type examination certificate, which is called Module B, must be obtained from the notified body. After this stage, for category 2 products, EU conformity declaration is prepared and the CE mark is added to the products. Different from category 2, for category 3 products, a quality control of product or system monitoring is required by the notified body once a year. Unlike all of them, for category 3 products, next to the CE mark, a 4-digit number belonging to the notified body from which the EU type examination certificate was obtained is added to the product. All right, we talk about the CE mark. What is CE marking? The CE marking is a key indicator of products compliance with the EU legislation and all appropriate conformity assessment procedures have been completed. CE marking enables the free movement of products within the European market. Member states may not restrict the placing on the market and entry into service of products bearing CE marking unless there is a supporting evidence of the product's non-conformity. The European Commission refers to the CE marking as a passport, which allows the product to be freely circulated within the EU single market. CE marking is not a quality mark. It means this product is safety. There are 7 notified bodies in our country assigned by our ministry for PPE. These organizations are included in the EU's new approach information system for notified bodies, and their conformity assessment services are recognized by the European Union. Notified body inspections are carried out by our ministry at the regular intervals. The third part of my presentation is audit structure. There are 22 full-time auditors in the market surveillance department, whose main duty is only auditing, and they are located in Ankara. Also, there are 57 part-time auditors in the other department of General Directorate of OSH, whose duty is to assist full-time auditors. They are also located in Ankara. Also, there are 54 part-time auditors, and they are working in the other region of Turkey. The total number of auditors in 133. You can see the regional distribution of the auditors on the map. As I said previous slides, there are 54 part-time auditors, and they are working in the other regions of Turkey. 4 persons in Bursa city, 4 persons in Adana city, 4 persons in Kayseri city, 23 persons in Ankara, and 4 persons in İzmir, and 8 persons in Kocaeli, and finally 7 persons in the Istanbul city. Now I would like to answer the question from chat in the previous presentation. Who are authorized to conduct the PP inspection? Audit personnel. Identifying cards are given by the ministry to audit personnel who have received training to conduct market surveillance and audit, and who passed the written and oral exams held at the end of the training. The majority of auditors are engineers who are ministry personnel. There are 3 main units in the market surveillance departments. First one is Safe PP use and guidance. This unit is responsible for strategic planning, performance monitoring, and reporting. Second one is market surveillance planning unit. This unit is responsible for preparing of audit plan, coordinating the auditors, and the managing results and reports. The last one is administration sanctions unit. This unit is responsible for preparing of the legislation and implementing administrative sanctions and coordinating inspections of notified bodies. Now, again, I would like to answer the questions from the chat again. Is there a different expert who undertakes the precautions when non-compliance is detected regarding PPE? First of all, the inspector who inspects the product prepares a report for the non-compliance. He or she detects the control organization checks the report. If the commission deems it appropriate, the necessary procedures are carried out and sanctions are applied. The final part of my presentation is activities and the meetings about personal protective equipment. The PP Technical Committee meets once a year under the chairmanship of the OSH General Director. Participation is provided in administrative cooperation and PP working group meetings held twice a year. Participation is provided in the market surveillance coordination board meetings held twice a year by the Ministry of Trade and in the market surveillance product safety evaluation board meetings again held once a year. Participation is provided in the A+A Fair, which is held every 2 years in the field of personal protective equipment and occupational safety. Thank you for your listening. Here is my email address. If you have any questions, you can ask via my email address. I think it was the last presentation for today. Have a nice day.
Thank you, Serdar Bey, for your comprehensive presentation. And this was quite an important matter for today's session. Dear participants, before we conclude today's session, we may receive a couple of questions. You may speak freely or you may write your questions in the chat box. Hamad Bey asks, what are common inspection failures in PPE? Serdar Bey, can you also see the question?
Yes. What are common inspection failures in PP? Can you open these questions? We can understand what is your aim.
Mr. Hamad Bey, would it be possible if you could elaborate your question so that we can answer a comprehensive matter?
Mr. Murat?
Hello.
Yes, okay. This is Sentongo from Ambrose. I could ask something. Is there, I would like to know from Mr. Etus if there is a lower document, well, it could be Mr. Etus or Madame Kuyuchu. I hope I'm pronouncing this correctly.
Mm-hmm.
If there are lower level documents or guidelines for the personal protective equipment below the regulations to guide the different either manufacturers or users or importers on what the regulations mean, some kind of interpretation guide or something like that. Lower than that, because in Uganda we are trying to come up with something like this, but we are still deciding on whether to start, for example, with guidelines or go straight to regulations. Usually we would want to start off with guidelines first. So if you have done something like that before already, maybe even in the future we can contact you for support in this. So, but please guide on whether you think it is if you started off with guidelines first, and what did you base your decision on that it should be regulations? Thank you.
Thank you, Mr. Ambrose. Merve Hanım, would you be able to answer that?
Yes. We can give you all legislation, and also we prepared lots of guides but they are in Turkish. We prepared them in our language. We can also share this with you, but it will be in Turkish.
Okay. I'm also checking the chat box at the moment. Ömer Sert Bey seems to have answered Hamat Bey questions, so thank you that. And
I didn't quite get an answer to the basis of why you decided to go straight to regulations instead of perhaps starting with guidelines. Was it a matter of there having been a weakness in Turkey that the manufacturers and the importers would not easily voluntarily comply? This is what I need to know. So it will help us to take a decision also here, whether to start off with guidelines or to go straight to regulations. If you could please just give your opinion on that.
okay. Merve Hanım, would you like to answer that?
I didn't understand exactly the question, but can you repeat it again? Why are administrative sanctions are so strict? Did you ask this?
No,
Did you mean this?
the question is whether to decide as a country to come up with guidelines for PPE or to go straight to regulations that have legal implication, because big regulations have legal implication, whereas guidelines are just there to help the people that use this PPE or manufacture it or import it to improve, comply, and to make the PPE safer, etc. So which do you think is better to start off with? The guidelines, which are really just for guidance first, so that you understand their usability in the country, among etc., or to go straight to something that is legally binding as a country? This is the question. I don't know. Is it any clearer?
I will try to answer. About 4 or 5 years ago, we inspect the PPs, go on markets and market surveillance. First of all, we didn't apply sanctions. First of all, we talk about with the manufacturers what will they do, and we tell them your PP is not not safe, and there's a non-conformity with your PPE, and we talk them. After last years, we started to apply administrative sanctions, and also we prepare lots of guidelines. What will they do? What is their obligations? And now I think administrative sanctions are suitable. Thank you. Am I clear? And am I answered your question?
Yes, I think I get it. You say that you started off with the market surveillance, and yes, before you
Yes.
came up with the
And later
regulations,
we apply the sanctions.
yes. Thank you.
In the meantime, there were a couple of questions, and thankfully, our valuable participants from the ministry are simultaneously answering at the moment, so thank you for that. Dear participants, for more questions, you may also speak freely, or you may write your questions in the chat box. In the meantime, I could address a couple of remarks before we conclude. For today's and tomorrow's sessions, the presentations will be available very soon. We will share them and we will inform you all as soon as the presentations will be ready. And additionally, tomorrow's session will be available using the same Zoom link. We will also send you a reminder email for that. And lastly, certificate of participation will be given to those who actively participated today and tomorrow sessions thoroughly. So thank you for that. I'm also checking in the chat box to see if there are any unanswered questions. There seems to be no further questions, dear persons. Miss Ali Hanım, would it be possible to close today's session?
Yes, Mr. Murad, thank you very much. I would like to thank you all our trainers and participants for the trainers and Ms. Nasib Gul for their kind contribution and sharing their valuable experiences and their great knowledge with us. Thank you so much, dear participants, for joining the discussion. Inshallah, tomorrow we will meet you at the same time at 10 o'clock Turkey time. And after the completion of the training course, we will be sending all the materials, the presentation of the training course to your email addresses. And I saw some messages they are asking in the chat box regarding the presentations. See you tomorrow at the same time. Have a nice day.
Have a nice day, dear participants. Thank you for your collaborations.
Most welcome. Thank you.
Thank you.
See you. Bye bye. Have a nice day.
Have a nice day.
Thank you and have a nice day.